While our panelists are taking the stage, let me start introducing them. We'll turn to the main event for the evening, entitled A Conversation with the Chiefs. We are so privileged to have with us tonight Chief Judge William H. Pryor, Jr. and Chief Justice Carlos G. Muñiz. Their discussion will be moderated by Judge Robert Luck, who, like Chief Judge Pryor, serves on the 11th Circuit, but who, like Chief Judge Muñiz, once served on the Florida Supreme Court as a justice. So that we can maximize the time for discussion, I will provide brief bios of each of our distinguished speakers, but please know that their many accomplishments are too numerous to detail here at length. Chief Judge Pryor serves as the Chief Circuit Judge on the United States Court of Appeals for the 11th Circuit, a court on which he has served since his appointment by President Bush in 2004. For 5 years, from 2013 to 2018, he served on the United States Sentencing Commission, including a stint as the acting chair of the commission. Judge Pryor served as the 45th Attorney General of the state of Alabama from 1997 to 2004. When he took office, he was the youngest state Attorney General in the country. Chief Judge Pryor is a magna cum laude graduate of Tulane Law School, where he finished first in the common law curriculum and served as the editor-in-chief of the Tulane Law Review. Chief Judge Pryor somehow finds the time to engage in significant scholarly pursuits, including serving as professor at the University of Alabama School of Law and the Cumberland School of Law at Samford University. He is also a widely published author, including as co-author with Brian Garner and Justices Gorsuch and Kavanaugh and several other judges of a treatise titled The Law of Judicial Precedent. Finally, on a personal note, I am obliged to note that Chief Judge Pryor is the first person who ever hired me for a job in the law, so I am grateful to him for that, and that he is a devoted fan of the Crimson Tide, which I should note is a team that did not win the national championship this year. But I'll also note that one time when my lovely bride and I were traveling through Alabama and we stopped in his office and I was wearing a Gator shirt, he nearly had the marshals escort me out of the courthouse. So he is dedicated to his team for sure. Thank you, Chief Judge Pryor, for joining us again at the Florida Federalist Society Conference. The Honorable Carlos G. Muñiz serves as Chief Justice of the Supreme Court of Florida. He was first appointed as Justice by Governor DeSantis in 2019, becoming the 89th Justice of the Court. Previously, Chief Justice Muñiz served as General Counsel for the United States Department of Education, where he provided legal and policy advice to the United States Secretary of Education, our lunchtime speaker tomorrow, and to other senior department officials. Prior to that, Chief Justice Muñiz had a long career in public service and private practice. He served for 3 years as the Deputy Attorney General and Chief of Staff to Attorney General Pam Bondi. Prior to that, he served as Deputy General Counsel to Governor Jeb Bush, as Deputy Chief of Staff and Counsel in the Office of the Speaker of the Florida House of Representatives, and as General Counsel of the Florida Department of Financial Services. Chief Justice Muñiz is a graduate of the University of Virginia and of Yale Law School, and I am told when he was there, they still taught law. Thank you, Chief Justice Muñiz, for joining us tonight. And last but not least, our moderator this evening is the incomparable Judge Robert Luck. Judge Luck was appointed to the 11th Circuit in 2019. Prior to that, he served as a judge at every other level of the judiciary in the state of Florida, as a Supreme Court Justice, a judge of the 3rd District Court of Appeal, and as a circuit judge in Miami. Judge Luck has, as they say, hit for the cycle in terms of judicial service in this state. Prior to his service on the bench, Judge Luck was an assistant United States attorney for the Southern District of Florida. In his years as a federal prosecutor, he was assigned to the Appeals, Major Crimes, and Economic Crimes section of the U.S. Attorney's Office. In his final year in office, he was the Deputy Chief of the Major Crimes section. Judge Luck is a magna cum laude graduate of the University of Florida Levin College of Law, where he served as editor-in-chief of the Florida Law Review. Judge Luck received his Bachelor of Arts in Economics from the University of Florida's with, of course, highest honors. Thank you, Judge Luck, for joining us. And in sum, I'll just say this: we could not have three more talented, honorable, or principled jurists than our guests this evening. Thank you all for joining us. Judge Luck, the floor is yours.
Good evening, everybody, and welcome to our conversation with the Chiefs. And Jesse, thank you so much for those kind introductions. So let's get into it. I know the Chiefs told me that they didn't want to waste any time and really wanted to have a great conversation tonight. So we'll dive right in. Now, the topic is called the conversation with the Chiefs, and so I thought the best place to start was asking the Chiefs what it means to be a chief. What does a chief actually do? And so I'll start with our Chief Justice, Chief Justice Muñiz. Now, it always seemed to me on the Florida Supreme Court, for the cup of coffee that I was there, that the Supreme Court justices wore three hats. There was the traditional hat of hearing cases and controversies. And then there's the hat of running the judiciary, and it's 1,000 state court judges, many of you who are here today, and the 3,500 state employees that work for the judiciary. And then finally, there's the hat of running the bar and the 100,000 lawyers that are members of the Florida Bar. It's a lot. And so I guess the question is that an accurate description of the way I described it? Is there something I'm missing? And what does the Chief Justice do in wearing each of those hats?
So thank you, Robert. That is an accurate description. And really, we have a very collegial court, and we have a court that by rule, any major decision that we make has to be done by our colleagues collectively. But the Chief Justice really is mainly responsible, I think, for being kind of the principal conduit between the court and the legislature, the principal conduit between the court and the Florida Bar. And then within the court, mainly kind of being responsible for taking the initiative and sort of setting our agendas for conference and kind of making sure that we sort of stay on task. I mean, obviously any justice who has something that they want to be brought up before the court can do that, but the Chief Justice is basically there to kind of, make sure that, we stay on top of things, stay as efficient as possible, and essentially, sort of represent the court, in our dealings with the rest of the branch and that sort of thing. So, Chief Judge Pryor, it's often said of chief judges and chief justices that they're, quote, the first among equals. Is that an accurate description of a chief judge of a federal circuit? And really, what by custom or law do you do differently than I do or Judge Lagoa does as our chief judge?
Well, the chief judge in a federal circuit has a lot of administrative responsibilities that many of you may not know about. You appoint all the committees of the circuit council, all the committees of the court. You represent the 11th Circuit on the Judicial Conference of the United States and work with the Chief Justice in ensuring that you have good representatives from our circuit on all the various conference committees. You also field complaints of judicial misconduct, which can then, depending on the disposition, be reviewed by some of the other judges as well, and a lot of questions of attorney misconduct and attorney issues in terms of renewal of bar applications get fielded first to the chief judge. In many ways, the circuit executive and the clerk of court are kind of chief operating officers in a sense of the circuit and of the court. But daily work with me and seek my guidance on really a number of matters. And I work with the chief district judges. In fact, next week I'll be meeting with chief district judges and clerks of court about all the various GSA building constructions throughout the circuit. So it's more than just presiding at the Court of Appeals re-hearings en banc or presiding at panel hearings. There are a lot of administrative responsibilities that go with being the chief judge, in addition to setting the calendar for the court. And if we're going to invite any judges to visit and sit with us to help us with our oral argument calendar, that's the responsibility of the chief judge, and particularly certifying the need for those appointments to the Chief Justice of the United States.
So I think when you become a leader, when you ascend to being chief, everyone, I think, naturally comes in with certain goals and priorities. And so, Chief Judge Pryor, when you take the leadership role and establish these goals, what sort of things did you have or want to do when you were coming into the role as Chief Judge that you said, I've served on this court for 15 years. These are some things I'd like to see done in the court that maybe hadn't been done. What changes have you seen or have done so far? And what do you still want to see with the remainder of the 4 or 5 years you have remaining on your term?
Well, I thought there were two things that I had seen the court deal with that required a bit of a different agenda for the future. One was our court had a tremendous amount of turnover in just the previous 2 presidential administrations. So Judge Wilson and I are the only active judges who were there when I arrived. Everyone else is either an appointee of President Obama or President Trump. We have one vacancy at this time. And that's a lot of new judges in a relatively short amount of time. And I thought our calendar had changed a lot. We weren't getting as many filings, and we no longer needed to have other judges from other circuits sit with us and help us with our oral argument calendar. That had been a real custom of our court, maybe somewhat controversial, and I wanted that to change, and I wanted all of these new judges who did not necessarily know each other very well to get an opportunity to sit with each other and know each other. And the other thing was, the generational change that had occurred on the court, I also thought was an opportunity to take advantage of a lot of technological advances that in some ways we hadn't, and to do more of our business electronically, be much less reliant on paper. Fortunately, one of the good things of the COVID pandemic was it forced us to do that, whether we wanted to or not. And I've wanted us to become a more efficient court. I think the courts are too slow, and I still feel they're too slow. And frankly, I think a lot of people a lot of Americans are opting out of the court system because we're too slow and too expensive. And I have no problem with private dispute resolution. I'd rather parties not have to come to the court to have their disputes resolved. But I hate for the reason they don't come is because they view us as too slow and too expensive.
Chief Justice Muñiz, so a similar question to you, except that unlike for a chief judge of a federal court, which typically spans 7-year terms, your term is generally 2 years and possibly to be re-upped another 2, but only lasts for at least a 2-year period. What are some of the priorities that you have as Chief Justice with the limited time that you have, and is 2 years long enough in order to get those things done that you really think the court needs to get done? So, with our court, obviously our casework, we're passive and we try to do our best to apply the law, according to our duty. Where we have the most discretion is with our rulemaking authority. And I've been very proud of the fact that our court over the last several years has kind of proactively done things to try to improve the efficiency and the fairness of our court system. We've tried to have some reform in the summary judgment area, apex doctrine. My predecessor, Chief Justice Kennedy, got the ball rolling on a work group to essentially try to institutionalize more proactive case management processes by judges, and we're in the middle of a kind of a rulemaking effort on that. And so, I want us to continue to be proactive on that front. I mean, I think our court has been good about using the best of the kind of the mechanisms that are available to us for rulemaking. We still rely on the bar committees to some extent and partner with them, but we also have been willing to use work groups that are outside of that system to do things on our own.
and essentially kind of keep our eye on, the ultimate objective, which is to serve the public and to make sure that our court system is as well governed as the rest of our state is, and to not let the process be an end in itself, to instead just let it be a means to the end of getting us the information that we need to be able to make the best decisions in the public interest. And then the other thing that I'm kind of interested in doing is making sure that the court has access to information about how the public and the people who use our court system feel that we're doing in a qualitative sense. There's a lot of data that's collected about, case filings and how long things take to be processed and that sort of thing, but more of the sort of soft, sort of qualitative types of input that I think can give us a sense of where we could maybe improve things. And so we have a thing called the Judicial Management Council, which is a group that's appointed by the Chief Justice that, I didn't start that. That's been in place for a while. But, basically that's a group that we're using to meet with people who are kind of frequent, high volume users of the court system to try to get their impression on how we're doing and how we can do better and sort of get beyond just the sort of raw data that we already collect, and that we continue to try to make improvements in terms of the data that we have access to, but also to get a qualitative sense of the people who most depend on what we're doing to get some feedback.
So I want to ask you two follow-up questions on both things that you said. I'll start with something you said, Chief Judge Pryor, and then I'll end with something that you said, Chief Justice Muñiz. So, Chief Judge Pryor, you mentioned about new members of your court. Both of you have had tremendous turnover isn't the right word, but a really new court. I've heard it said on the multi-member courts that every new member that joins, it becomes a new court. It's almost as if you're putting like a new arm or a new leg on a body, it becomes a new body. I wonder, Chief Justice Muñiz, if you agree with that, especially given that since 2019, you've had five new members of your court, including you, and I'm interested in what those changes have impacted the court, and also what things you want to preserve or to make sure to preserve with all that new membership on the court.
Well, I've been blessed that, despite the turnover, everyone, we have still managed to maintain a lot of collegiality. And that's notwithstanding the fact that increasingly people on our court, as a lot of you probably know, aren't moving to Tallahassee like I think people historically did. I think it's a net benefit to the court that we have people who are able to still stay connected to their home areas. I mean, as you know, Tallahassee's a great place. It's where I've lived for the last 20 years, but it is kind of isolated from the rest of the state and obviously very different. I've been, I think it's in our court, I think over the last several years, I think it's become clear that we have a supermajority of justices who have kind of, through our work, committed to a certain judicial philosophy. We've, come out with some decisions on precedent that I think have given people a clear sense of kind of how we view the law of precedent and how we're going to apply that. And I think it's good because obviously I agree substantively with what we've done. Well, I respect that obviously people have different views on that, but I think that there's a benefit in, the accountability that comes from us having sort of staked a position on that's clear. I think we've sort of made a conscious effort to be explicit about methodology and that sort of thing. And I think having colleagues where we obviously don't agree on every case, even those of us who kind of agree at the level of first principles about what we're trying to do, but I think it makes for very interesting discussions within the court with people who do agree kind of on the first principles, and then you can have, obviously very interesting discussions in each case about how best to apply those, where, sometimes if you have a colleague, if you completely disagree at the level of first principles, then, there's only so much that discussion is going to get you. So, we have a very collegial court. Obviously, I was, sad when you and Judge Lagoa, moved on to the 11th Circuit. Obviously very happy for you guys personally, but really every person who's joined our court and the colleagues, it's great to have former Justice Lawson here, and I have a couple of great predecessors as chief. So I'm really incredibly blessed with the court that we have.
So Chief Judge Pryor, you mentioned about a lot of change on the court. half of the judges on your court have joined within the last 5 years. And as you mentioned, I'll highlight that statistic again. There's only one active judge on the court from when you started in 2004. That's a lot of new people. Right. Tell me, how has that turnover or that change affected the 11th Circuit at all, if it's affected at all, and what effect has that had?
Well, I think the job of collegiality that Carlos mentioned is a constant one. Fortunately, I think, well, I'll say two things. One, there's always the challenge of maintaining collegiality. The second is you also don't want to lose a lot of institutional knowledge. Now, we were fortunate in that a lot of the judges who have joined our court in the last several years, I'll go back more than 5, Judge Rosenbaum, clerk for Stanley Marcus, so she was familiar with our court. She and had knowledge, both institutional knowledge and knowledge of our collegiality. Judge Jill Pryor had clerked for Larry Edmondson. You had clerked, of course, for Ed Carnes, my predecessor as chief. Of course, Judge Wilson had clerked on our court, and Judge Brasher had clerked for me. That's helped, but I think that's probably the greatest challenge. And I was the only judge during the Bush 8 years, George W. Bush years, appointed to our court. So for a long time, I guess it felt like the first half of my tenure on the court, I didn't know what it was like to have a judge join the court and change the court. But I saw a lot of judges come on the court in rapid succession, and it really did change the court markedly. And I think those are the two biggest challenges. You want to maintain the collegiality. I think we've done that. You want to maintain institutional knowledge. We can't do it, frankly, as well as we do it without the help of our senior judges. They shoulder a good bit of the burden, not only of our casework, but our administrative duties as well. And I'm very grateful for it. So,
Chief Justice Muñiz, you mentioned about qualitatively how people view the courts. And I want to ask about that. So every year since 1997, the Gallup poll asks about trust and confidence in the judicial branch generally. And it splits the question up into 4 different parts. Part 1 is, I have a great deal of trust and confidence in the judicial branch. Part 2 is, I have a fair amount. Part 3 is not very much. And Part 4 is none at all. Now, last year, the not very much and none at all answers had the highest percentage since the poll started, 53%. Only 7% said a great deal of confidence, the lowest ever, and only 40% said a fair amount, also the lowest ever. So I guess my question, and I'll start with you, Chief Judge Pryor, but I'll get to Chief Justice Muñiz, is what do you think is causing this spike in the lack of confidence and trust in the courts, and should these declining poll numbers be a concern of the courts?
I think the declining numbers should be a long-term concern of the courts, but not something that the branch was created to be independent and to withstand popular pressure. Our task is to uphold the rule of law, and that will not always be popular. And we should always keep that foremost in mind. As for the reason for this, I will be blunt. The reason for this is because there is a relentless campaign in the media and in elite opinion circles in our country to attack the courts. And the reason is because we have entered an era where the courts are no longer going to be in the business of enacting a political agenda that cannot be accomplished through the political branches that the elite opinions favors. The American people have to govern themselves. We have elected branches, we have political branches, there to perform that role. They're the accountable branches. They're the responsive branches to the voters. And we have divisions of responsibility under our constitutional structure between the federal government and the states. And I think there's going to be a better respect. There already is a better respect for that division of structural responsibility. And it's not popular in many elite circles in our country. And I think there's a responsibility on the part of the bar to defend the courts, to defend what we're doing. All of you who are here have a role to play. But I'm not here to apologize for it. I'm proud of the work that we're doing. I'm frankly proud of many decisions, recent decisions of the Supreme Court, where the Supreme Court has adhered to the text and original meaning of the Constitution. But it's going to come at a cost in terms of popularity, but we can weather it. The country's weathered a lot of things. The Supreme Court, frankly, has been the source of a lot of the worst divisions in our country's history because of wrong decisions. Dred Scott caused a civil war, after all. Good decisions over the long haul will be appreciated.
Chief Justice Muñiz. Chief Justice Muñiz, Chief Judge Pryor said that we, the lawyers, have a role to play in defending the rule of law in the courts. What role does the Chief Justice and the Florida Supreme Court have as leaders of the bar and leaders of the branch in strengthening the public's faith in the state court system?
I mean, I think the main thing that we can do is just do our jobs as well as possible. We have to, and I really can't improve on what Chief Judge Pryor said substantively, but, when
I've had that same thought many times.
When I read about, and I think this is, over history, the court has always been, the court has always sort of had its ups and downs as far as popular opinion. And so I think, I kind of take it as a, kind of a challenge in a way to really make sure that we really do pursue excellence, that we really do practice what we preach. We speak through our opinions, and we have to, if we want to be trusted, then we have to make sure that we explain ourselves well and, treat people with respect and, show up prepared. I think, in the state courts where so much of people's kind of everyday lives where they do have to interact with the court system, I think, at all levels of the branch in terms of, running a good, local court operation, treating people well, being on time, being prepared, showing people that even if they disagree with what you're doing, that, that you've given them, a fair hearing and made a decision based on law. And I think if you just sort of stay focused on excellence and, doing the best you can to, explain the legal basis for your decisions, I think over time, things will take care of themselves.
So I wanted to switch gears a little bit. And I was thinking, you two really have never met in person before, I don't think. I know you've interacted a little bit outside, but never in person before. But in looking at your bios and looking and knowing both of you, there really is an incredible amount of overlap in your careers. And I wanted to ask you about some of those things to get a little bit to the more personal. So the first of that is, you both were born and raised Catholic. And currently on the Supreme Court, 6 of the 9 justices were born and raised Catholic. On the 11th Circuit, I think a third of the court is Catholic. On the Florida Supreme Court, almost half the justices are Catholic. And I have to ask Chief Judge Pryor, is there a reason for this? Is there something about being Catholic that makes for good judges and justices?
Justice Scalia used to say, well, there's not a Catholic way to make a hamburger. So it's not a special qualification for being a judge. But I would say that there is something about the Catholic intellectual tradition, the emphasis on tradition, the emphasis on history, the emphasis on the natural law tradition, that frankly is attractive to a lot of people in the legal culture. A lot of lawyers are attracted to that, and it's a coincidence that I've seen a lot. That doesn't mean you have to be Catholic to be a good lawyer or a good judge. I'm not saying that, but for whatever reason, there is something about the Catholic intellectual tradition that I think is attractive to a lot of lawyers.
I think there is a Jewish way to make a hamburger, but the point is a good one. The point's a good one. Chief Justice Muñiz, what, if anything, about your Catholicism has helped you to be a good justice, to be a good deputy attorney general, to serve in the way that you have served the last so many years?
Well, I think, for me, Catholicism, my judicial heroes, I think the fact that Justice Scalia and Justice Thomas are both Catholic and outspokenly Catholic has always kind of been an inspiration for me. I think it's interesting that neither one of them, as far as I know, other than, I know Justice Scalia says, be perfect as your Father in heaven is perfect, and just the idea that, part of Catholicism is kind of encouraging you to view your work as a vocation and all that, which obviously that's not unique to Catholicism, but it is stressed. But, I remember as a young person going and seeing Justice Scalia at a Knights of Columbus meeting give the two Thomases speech that, is one of his staples. And to hear someone, give, a speech that had that religious subject, but obviously kind of had relevance to work too, in the sense of, don't let being denigrated by sort of intellectual elites and that sort of thing, don't let that deter you from, doing the right thing in terms of judicial philosophy. And obviously there was the religious message of don't let, the disapproval of the world sort of knock you off your path from a faith perspective. And then Justice Thomas, I've always been very moved by his accounts of, the role that Catholicism and his faith played in, his devotion to his grandfather, but then also, kind of getting his own life back on track and overcoming anger and that sort of thing. And then the other, kind of from a negative perspective, the fact that Justice Brennan was Catholic, and the sort of Mario Cuomo approach to Catholicism and that sort of thing, that was something that I always, I thought a lot about that kind of in my formative years. And so I definitely have not just assumed that, every person who says that they're a believing Catholic is necessarily going to approach the law exactly the way I do. But, it's really for me just been more that, my heroes have been Catholic and lawyers, and, it's just they've been good, kind of from afar, good role models to have.
Now, another commonality among many that we'll talk about is you both joined the Federalist Society early in your legal careers. And this question really is to both of you. I'll start with Chief Justice Muñiz. Why did you join the Federalist Society as a young lawyer and law student? And how has the society helped you to be better a lawyer, better at your job, better at what you do now?
They were sane people.
You weren't yet.
No, I mean, obviously I agreed substantively with what the society stood for, but equally important, it's not just rhetoric. I mean, I think, my experience has been that Federalist Society chapters in schools really do, they do want debate. They bring in speakers on all sides of an issue. They bring in good speakers who disagree. It's not, let's set up some, clown to come and debate, the most, the smartest conservative in the world. I just appreciated substantively and just sort of the culture of it. And it really was a great thing, at Yale, obviously, you're kind of in a minority philosophically, and so it was just good. It was just good to have that presence there.
Chief Judge Pryor, same question to you. I've heard you tell this story before. I think we have a lot of young lawyers and law students here. How did you come to the society, and why is it important that you've been involved?
So I showed up at Tulane for 1L orientation in the fall of 1984. One of the students who was there to introduce a lot of students were introducing extracurricular groups, but one stood up to introduce the newly formed National Lawyers Guild chapter, and told of its history and how it was formed as a liberal counterweight to what he described as the conservative American Bar Association. And I thought maybe Tulane needed a conservative voice on campus, and I had read about the Federalist Society in National Review, so I went back and looked at several of my back issues and found an ad for the Federalist Society with a long distance number in Washington, and called it, and its first and only employee, Eugene Meyer, answered the phone and told me that there was already a student at the law school who had contacted them about forming a chapter. And so we planned an event with Walker Percy, the novelist. His brother, Finn Percy, was on the faculty at Tulane, a UVA grad, and he was our first speaker. And the Federalist Society allowed us to hear perspectives and debates and ideas that we would not hear necessarily in the classroom, and in a real way completed, fulfilled out our legal education in a way that unfortunately a lot of law schools don't do because of an orthodoxy in the hiring of their faculty. And soon afterwards, the Federalist Society was forming practice groups and lawyers chapters. And when I graduated, it was just the natural thing to do to help start some lawyers chapters. So I did that as well.
Now, again, another commonality that strikes out, and Jesse mentioned this, you both clerked for legendary Hall of Fame, Mount Rushmore level Federal Circuit judges. Chief Justice Muñiz, you clerk for Judge Cabranes, who is now a senior judge in the Second Circuit. He only recently took senior status. Chief Judge Pryor, you clerk for Judge John Minor Wisdom, who served for decades on the Fifth Circuit. Chief Judge Pryor, for many of the young lawyers and students here in the room, I don't think they may have heard of Judge Wisdom. Can you tell us a little bit about him and what you took from the experience of clerking with him?
Yeah, if you want to talk about courage and not worrying about popular opinion, you ought to study the lives of these were actually mostly Eisenhower appointees to the federal courts in the late 1950s who made Brown versus the Board of Education a reality in the Deep South, who implemented desegregation and weren't doing it from afar. They were doing it in the Deep South. They were having rattlesnakes in their yards, obscenities when their children would pick up the phone, being shunned in clubs that they had belonged to all their lives, having, one judge in Alabama had garbage strewn on the grave of his late son. They really saw what it means to stand up for the rule of law, and they lived it. And Judge Wisdom was one of those judges. He was a patrician, an aristocrat, really from New Orleans, who had a thriving legal practice, but had become involved in the Republican Party because he stood up to Huey Long and his corrupt machine in Louisiana, and saw the Republican Party as the way to counter the Huey Long Party, and because of the work that he did with the early Louisiana Republican Party and with the Eisenhower campaign, he, after turning down the opportunity the first time, something I share with Judge Wisdom, he when they came back to him and asked him again to consider being an appointment to the Fifth Circuit, he took it and became a legendary judge. Judge Wisdom, one of the things I take away the most from my experience with him was how he treated his law clerks. The best part of my job is working with my law clerks. We would take turns taking Judge Wisdom to work in the morning and taking him home in the evening. He would invite us to dinner in his home, and he really treated the law clerks like extended members of the family. And a lot of traditions I've created with my own law clerks started from emulating Judge Wisdom and the traditions he established with his.
Yeah, that deserves some clapping. So, Chief Justice Muñiz, you clerked for Judge Cabranes, who's a legendary judge in the Connecticut, New York area. Can you tell me a little bit of what you learned from him and how you've applied that as Justice and Chief Justice? Yeah,
no, I love Judge Cabranes. I mean, the two things that I most associate with him are patriotism, and he loves the United States, he loves the Constitution, and just his work ethic. He's a very hard worker. He loves people. He loves people's stories. He grew up in New York and just loves, all the kind of variety of stuff that you encounter there. Big fan of reading the obituaries in the New York Times and, telling stories about people, many of whom he would have come into contact with. And he's another one who's, was very devoted to his clerks. I mean, you definitely felt like you were joining kind of a team, a family. Just today, I got a 4-paragraph long email from him encouraging me to meet a young guy who just, I guess, moved to Tallahassee to start working in state government and, is kind of on a similar path to what I did. And it wasn't just sort of 2 sentences, hey, here's this guy's number, can you call him? It was, this big long thing about, the background of this person and how great he is and all that. And, he's done things like that for me countless times. He's always very encouraging. And, I can't say enough good things about him.
Now, Chief Judge Pryor, you mentioned this, both of you have, but you mentioned this in your earlier comments. But both of you, both from what your writings and knowing you, are committed originalists and textualists. Chief Judge Pryor, you've written, quote, "Originalism has been restored as the primary interpretive philosophy of the judiciary." And as Justice Kagan famously said, I know I've quoted it myself, we're all originalists and textualists now. But even among those whose primary interpretive philosophy is originalism and textualism, there seem to be disagreements. One high-profile example was the disagreement between Justice Gorsuch and Justice Alito over the meaning of Title VII in Bostock. And then, trying to think of another example, one of what we're a part of, and that comes to mind the safety valve issue after the First Step Act amendments. And I won't get into the weeds of what the safety valve is in the First Step Act amendments, but so far on that legal issue, the 6th, 7th, 8th, 9th, and 11th circuits have weighed in. And let me give you the split among judges. Judge Kethledge, Judge Batchelder, Judge Oldham, Judge Branch, Judge Grant, Judge Brasher, Judge Colliden, and Judge Kobes have read this statute one particular way. And then Judge Griffin, Judge Willett, Judge Newsom, Judge Lagoa, Judge Boggs, Judge Smith, me, and most importantly you, have read it another way. So my question, that's a long wind-up, how do two groups of judges, all committed textualists and all purporting to apply the same interpretive philosophy, reach different results? Are these the sort of disagreements that are common among originalists and textualists since it's been restored as the primary interpretive philosophy?
No one said judging was easy. It's not an algorithm. It's not a computer program. There are disagreements among textualists about what canons of interpretation are valid or not. Some say that the absurdity canon shouldn't be used at all. So you're going to have reasonable and good faith disagreements among any group of judges, no matter how committed they are to the same basic vision about the rule of law and adherence to written law, the written law of particularly the political branches. Now, You know, I can't excuse how a number of judges could make the word "and" mean "or." All the judges on my camp that you listed, and you're among them, understand that "and" means "and." And that's what that First Step Act controversy comes down to. But we're going to have reasonable disagreements. Justices Scalia and Thomas had disagreements after Crawford versus Washington about the confrontation clause. They agreed about it. They had the same perspective in Crawford, but when then Crawford was applied in a lot of other cases, particularly about scientific and lab type testimony, they had some disagreements, ended up on opposite sides. So we shouldn't expect that judges are always going to agree. That's why we have appeals. That's why we have multi-member courts of appeals and Supreme Courts, because we recognize there can be good faith disagreements about the rule of law.
We should add Judge Lagoa was with us on that one, too.
Absolutely. Right, Judge Lagoa was with. She knows "and" means "and."
Chief Justice Muñiz, Chief Judge Pryor mentioned honest and good faith disagreements. Do honest and good faith disagreements between textualists on the meaning of a statute undermine or sow doubt into textualism as an interpretive philosophy? And are these kind of disagreements bugs or instead features of originalism and textualism?
I mean, I think like Chief Judge Pryor said, I mean, you know, it's not reasonable to expect that just because judges agree kind of on first principles and on, you know, basic issues of methodology that they're always going to get the same answers. I mean, I think, you know, the more you read about textualism and you know, you read honest textualists, you know, there's an acknowledgement of the fact that it's not, you know, it's not a math, it's not, you know, a mechanical thing. I think in addition to disagreements sometimes about specific canons, I think different views about context, you know, textualists all start from the premise that context is critical, and once you acknowledge that, then naturally there are going to be debates about how narrowly or broadly you define that. But I think, you know, as I mentioned earlier, I do think that it's nice to debate people where you at least agree on what the goal is, and you can have sort of good faith disagreements about that. I mean, as I mentioned, our court now, I think, has a supermajority of people who self-consciously try to do law that way, but we still disagree. You know, occasionally my hero and colleague Charles Kennedy and I, you know, once in a blue moon will disagree on things, and it's not because we have any disagreement at any, you know, fundamental level of principle. But it's just sort of, you know, in the nature of things.
Now, again, despite the busy schedules you have, and Jesse mentioned this as his introductions, both of you have made time to speak to students and lawyers in your home states and beyond. For example, both of you recently have spoken about Professor Adrian Vermeule's book, Common Good Constitutionalism. Now, Chief Judge Pryor, you gave a speech last month in Tampa, so thank you for coming back to Florida, to our Tampa chapter, and the speech was entitled, quote, Against Living Common Goodism.
Yeah, that's my favorite way to refer to it, living common goodism.
All right. I'll try to use that terminology.
Good.
And Chief Justice Muñiz, over the summer, you moderated a discussion about Professor Vermeule's book called Common Good Constitutionalism, a Constitutional Interpretation Theory and Its Critics. So Chief Judge Pryor, why has Professor Vermeule's book generated so much discussion and heat that you and Chief Justice Muñiz would take time to talk to students and lawyers about it? What is common goodism, and why should we be against it?
Well, the reason I've taken so much time to speak out about it, there's really a lot of reasons. First, Adrian Vermeule has argued that originalism and textualism are inventions of the 1970s and 80s conservative legal movement that were designed to achieve conservative political victories. And I've lived through that era, and I know that is false history. I know that, in fact, the true history is that originalism and textualism have been restored as the primary interpretive methodologies in the manner that Chief Justice Marshall and and Justice Story and some of the greatest jurists in our earliest history championed and practiced. So I knew that was a false history. I also think that it's that saying that we needed to discard now originalism and textualism and adopt a methodology to secure more consistent conservative political victories is antithetical to the rule of law. And the reason that I call this living common goodism is this is just a fancy conservative version of living constitutionalism. And frankly, can y'all not hear me? This is everything that I became, every reason that I became interested in the Federalist Society and in the proper role of the federal courts, everything that I believed in to the fiber of my being as to what that is about and what the rule of law is about is contrary to what he's peddling. And he's peddling it to a lot of young law students who I think they'll look upon a decision. I don't want to name any particular decision. You could probably guess a decision where they say, oh, well, if that's originalism and textualism, I don't want any part of it. And there can be honest and reasonable disagreements, as we were just mentioning, among originalists and textualists, and they're losing sight of that. But to some degree, I think there's a younger generation of law students, particularly at elite law schools, who say, yeah, that was then, that was cool then, but we want to be part of a vanguard of something new. We want to take on kind of the establishment and show a different way, a better way for the future. And in a sense, I think Adrian has captured that. I think his primary interest is in defending the administrative state, and a lot of those who are enamored with him right now ought to think long and hard about the implications of that. But the big debate about what is law, what is the nature of law, there's a lot I think I could agree with Adrian about what is law and the nature of law. But if the question is, what is the role of a judge in the Anglo-American legal tradition, and particularly, what is the role of a judge in interpreting our written Constitution and our written laws in an age of statutes, then I think he's got it all wrong. The idea that we can take advantage of what he contends are majestic ambiguities and generalities in the law that good historical inquiry would show really aren't such generalities and ambiguities, and then craft a philosophy that promotes the common good from a particular political orientation is just antithetical to the rule of law as I understand it.
Chief Justice Muñiz, how would defenders of common good constitutionalism or living common goodism respond to the critics? Do you think common good constitutionalism has a place in interpreting the Florida and federal constitutions, and what is that place, if any?
Well, I think the main, I think a lot of so Professor Vermeule's book, I think, the good thing about it, I think, is that it has prompted a lot of interest in what he calls the classical legal tradition. And I think that's what the things about the nature of law and that sort of thing. Obviously, he has a view of the particular American Constitution and legal tradition, and then beyond that, he has sort of these the kind of these normative views, which really aren't even conservative, a lot of them. But I think that he has really brought a lot of attention to the work of people like Joel Alicia at Catholic University, Kevin Walsh, who's there, Jeff Pojanowski, people who I think have done a lot of really good thinking about the connection between the natural law tradition and originalism and the role of a judge. And I think that, one of the reasons why I think younger people are probably interested in it, I think maybe part of it is just, wanting something new. But I think people do have a hunger for understanding sort of the moral foundations of law. And I think that, the healthy part of the debate, I think, is not so much necessarily the judicial role in that, but really to get people thinking about what is the law, what is the purpose of law, are there enduring moral principles, is there truth, was America founded on a common belief in certain truths? I think people have probably read more Aquinas in the last couple of years because of this debate than, the last 50 years before that combined.
So it's a Catholic plot.
So I think a lot of the prescriptions in Professor Vermeule's book are necessarily ones that I think most of the people here would necessarily buy into, but I think that it has focused on some long-standing ideas about law, about the American tradition, I think there's a lot of learning there, I think, to be done by people.
Now, the last common bond, we can go on this, but the last one I wanted to talk about is a personal one. Now, both of you are husbands and fathers, and I've had the opportunity to talk to both of you about your families over the years, and both of you, the same way, immediately light up when you talk about your children. And so all I want to do is, aside that maybe we don't all get at these things, but you just tell me maybe a little bit about your families and what it means to be a husband and a father and how that helps you to be better at your job. I'll start with you, Chief Justice Muñiz.
Well, I'm blessed to have a great family. I met my wife, Katie, here in Florida when we both worked for Governor Bush a little over 20 years ago. I think the first person I told that I was going to ask Katie to marry me may have been Charles. So he was present at the creation there. But we have 3 kids. Our oldest just started college. Our other 2 kids are still at home. Our kids are homeschooled, which, Katie deserves 99.9% of the credit for that. Thanks. All of our kids are born and raised in Tallahassee. And, I've just been blessed that they've, just been, I couldn't ask for, more support. I'm sad that I only have maybe a few more years of our younger 2 kids being at home. It's been a big adjustment with our oldest going to college. But
Chief Judge Pryor.
Smartest and maybe it's just luckiest decision I ever made was marrying my spouse of now 35 years, who is a CPA. She's a tax partner in a regional accounting firm. So in the coming weeks, I'll see a lot less of her as we approach April 15th. But we've had, she's had her own terrific career, and I think the value that she and our daughters bring for me is keeping me humble. And I'm no big deal. I'm not judge at home. And we have two great daughters who now they're married, so we're empty nesters, Carlos. It's not all bad. And they're married. Our older daughter lives in the Nashville area and has been working ever since she graduated from the University of Alabama in the wine industry. And so whenever I have a choice on a wine list, I can just text her a photo and ask her which one to pick. She's a real sommelier, and is married to a great guy. And even if he did go to Tennessee, our younger daughter went to mama school, graduated from LSU, but got her master's in economics at George Mason, and now works. She's the economist on the minority side of the Senate Commerce Committee, where Senator Cruz is now the ranking member. And she married very well. She married the former president of the student body at the University of Alabama. And they're expecting our first grandchild. So I'm very happy about that. I wanted to say something, though. Jesse had brought up the Alabama and Florida thing. I don't remember attacking him for wearing the Gator shirt. I want y'all all to know that when God created the SEC championship game, he meant for Alabama and Florida to play in it.
But who to win?
Well,
but who to win?
He started it off right. He wanted Alabama to win, and we did.
We'll end. We're about at the end of time, and I want to end with a few final thoughts. So, as I mentioned to our panel, we have a lot of law students and young lawyers and some new judges in the audience. And so, Chief Judge Pryor, what advice would you give a law student and young lawyer just starting out in the profession? And maybe the way to phrase it is, what would you want to know if you were just starting out today?
Well, I would say a practical bit of advice as a lawyer is the most important skill that you will have as a lawyer is writing. Written communication is how we do most of our work, and that's going to continue to be the case. And your job in honing your writing, improving your writing skill will never be finished. Any good writer is never satisfied with the quality of their written work, and so you should always keep working on that. And you know, the practice of law is very hard. You need to be prepared for hard work. You need to have balance in your life. But it's really important for you to have that balance too in your friendships and how you treat fellow law students, many of whom are going to end up practicing law with you if you stay in the area where you're going to law school, and you're going to be seeing for many years to come, and they're going to be your colleagues. This is a profession, and so you need to be kind and good to them, and forgiving of them, and be a help to them, because they will help you and be a friend to you someday as well.
Chief Justice Muñiz. Chief Justice Muñiz, what advice would you give to a new state judge who just joined the bench? And again, what do you wish someone told you when you were just taking the bench in early 2019?
I would tell them what you told me when I started, which is you have to earn it every day. And when I had an opportunity to speak to a lot of new judges, I encouraged them to focus on gratitude in terms of just the great blessing that we have to serve in this particular way. Excellence, to always pursue that, and then service, which I think if you keep yourself focused on service, I think you'll do a good job. I think that over time it will address a lot of these issues that we were talking about with confidence, and I think it will also sort of cultivate the spirit of humility that you need, both from in a philosophical sense, but also in terms of the way you treat the people who come before you.
So Jesse started off by saying that that deserves clapping too. Jesse started off by saying that it'd be hard pressed to find two brighter, more hardworking, and frankly more principled judges that serve on the state and federal judiciary. And I've had almost word for word those exact sentiments. So we are honored to have this panel, and we owe them a big thank you for coming and joining us today.
That was fun.